Mr. Diwan, I was actually reflecting on what you said at lunch.
Yes.
See, look at it this way: when the law provides for, I may be wrong, I'm just formulating it.
Yeah, but let's see 682. Yes.
When the law provides for a deeming consequence,
Yes, correct.
that consequence operates without any adjudication or without application of mind to the facts of a particular case.
Generally, but not here,
that
maybe.
law, the deeming consequence, what we call a deeming fiction, for
I would accept that.
right? Now, when the consequence is called into question in an individual case,
Yeah.
on the ground that the conditions requisite for attaining that consequence are absent, your four conditions. The fact that those four conditions were not satisfied, or any of them was not satisfied, and therefore the person is not entitled to the benefit of the deeming consequence, is always up for adjudication.
That's
so
that's
suppose,
not the
for
scheme.
instance, somebody, I'll tell you, somebody now a person prior to 66 applies for an Indian passport.
Yeah.
All right. Or their child, now there'll be those people who will be now, as you
57
said, 57 years old. Already that person applies for a passport.
I mean, at least 50.
The passport officer says that, look, I can't give you a passport. You're not an Indian citizen. Then at that stage, if he says, no, I'm an Indian citizen by virtue of 682, I'm not saying the passport officer will do that adjudication. He has no power to do that adjudication. But certainly, the validity of his status can be then decided. Suppose somebody applies for some other social welfare benefit which is available only for a citizen. Otherwise, we can clarify that actually, that this is not, that anybody who claims that status gets the status.
So let me just answer this. Now, your Lordship has formulated. So I have 2-3 answers to it straight away. So just look at 682, please.
Yes.
Just have a look at 682. I'll just read some parts of it. You see, subject to the provisions of 6 and 7, all persons of Indian origin who came before 1st January 1966 to Assam from the specified territory, including those, etc., who were included in the electoral roll for 67, and who have been ordinarily resident in Assam since the dates of their entry into Assam, shall be deemed to be citizens of India as and from first day of January 1966. And as your Lordships have seen, this provision comes onto the statute book with effect from 7th of December 1985. So it has, the deeming is not just deeming with regard to who becomes a citizen, but also from when the person becomes a citizen. That's very important. Deemed to be a citizen as from 1st January 66. Now, we're not going, there's some rationale provided, etc., because there were elections held, etc. We're not getting into any of that. I am first examining this subsection facially. So assume everything is, what it says, what it means to say. So 4 conditions, your Lordship have specified. I don't want to repeat it. Now, look at the manner and the mechanics of it. First question, are there criteria? I'm just asking myself.
Criteria there are.
I believe there are criteria. So you cannot assail a provision on the ground that this is just being handed out to anybody and everybody without criteria. And criteria is necessary, I believe, for the grant of citizenship. There must be some rational application of mind, some objective criteria. Now, there are objective criteria. That's the other part. It's not just criteria, they are objective criteria.
Right.
Now, those objective criteria are on the basis of certain fact situations. Now, I'll take a simple one. You have to enter into Assam. That's my other point, but let's keep that aside. Not West Bengal, not enter. It has to be to Assam. That's one point. It has to be prior to 166. It has to be from Bangladesh. And you have to be thereafter resident. Now, all these elements, I'm just suggesting to the court, because what is deeming? Deeming, according to us, is a basket of rights.
Just there has to be a machinery.
Yeah. No, so I'll come to that. It's a basket of rights. Citizenship is a basket of rights. And that basket of rights includes political rights, it includes civil rights, it may include social rights, it may include economic rights. This is a very important concept because that will also tie into some tentative observations were made of does proportionality have any role in this, and we'll try and suggest some solution.
What the Chief is saying is this.
Yeah.
You are right. Now it is ultimately for the individual to have his own view of satisfaction of these four criteria.
Yeah.
Now
there's also the
merely because subsection 2 does not speak about it.
Yeah.
The question is, will that take away the power of the state government
Right.
to go into that issue and satisfy itself whether A or B satisfy this.
So may I answer that?
Yes.
I'll answer that straight away.
Okay.
My respectful submission is that and there'll be some guidance from some case law, which I'll place presently. But once you specify criteria, you must, in the facts and circumstances of this case and having regard to the nature of this provision, have a machinery to determine those
But see,
criteria.
a deeming fiction is provided by the Constitution itself in Article 7.
That,
The Constitution itself provides for a deeming grant of citizenship in Article
yes,
6.
yes.
There is no machinery in Article 6. Of course,
Yeah.
you can't challenge an original provision of the Constitution
Yeah,
that it is
yeah,
a
yeah.
violator of the. See, Article 6 also says,
Right.
so, notwithstanding, etc.,
Yeah.
shall be deemed to be a citizen of India at the commencement of the
I
Constitution.
accept that.
So, even the Constitution.
But that is a
didn't
starting
provide for
provision, Manoj. Someone had to be a citizen of India. So there was a cut-off date which was prescribed and there were provisions which were made. That's very different according to us.
But
Sorry.
if somebody were to claim the benefit of Article 6 citizenship,
Yeah.
then the question as to whether he or she satisfies
there be a
clause A,
contest?
B,
Right.
that can be gone into.
So may I answer that by in this manner? I accept the provision, I accept the position that you may have certain circumstances, such as at the inception of the Constitution or at the starting of the Constitution, when you may not require to have a case-by-case determination insofar as individuals are concerned. However, the nature of 6A2, and I'm not putting it any higher than that,
Yes.
6A2, by prescribing objective criteria, required, according to us, a machinery to ascertain those objective criteria in individual cases. It can't be just as a defense mechanism when someone wants to take action against you that it happens. Because you're conferring a basket of rights, including political rights and the full range of rights. So that, Manoj, is my respectful submission. Yes. And according to me, our submission is that this is fatal as far as this. Because otherwise it really amounts to saying, now I'll just flip it around. Supposing they had provided no criteria. Ultimately, that's what it means. If you are not providing a machinery, it is a criteria-less citizenship with a date of 1st January 66, because nobody is required to go through any evaluation process at all. That's exactly as the Chief Justice correctly observed, that probably happened at the inception of the Constitution, where there was a presumption that everybody who was there on or before a particular date is deemed to be the citizen of India. So that's okay there, but is it now okay here is the question for your lordships to consider. Yeah. Right. Yeah. That permit system, etc., has been explained to your lordships. So these, my lords, are my submissions as far as 6.2 is concerned. Now I want to go to 6A3. I'm sorry.
6A3.
Yeah. Now on 6A3 again, first point, no time limit. I think that's common ground. Now, if no time limit is provided for working out this section, according to us, the section itself is vulnerable, and I have premised this submission on the basis that we suggested a few expressions that the provision remains on the statute book and continues to act as a beacon indefinitely. It's like a magnet which attracts people to Assam with all the consequences as far as illegal migrants are concerned. And therefore, in our respectful submission, this itself, this is a fatal element to it, namely that there is no time limit which is prescribed within which this process is to be completed. It can be done tomorrow as well. That's open-ended, and that's very, very dangerous and wrong and illegal according to us. So this is our next respectful submission. Now, Malad, I'm focusing on another concept, and the concept which I'm now focusing on is person ordinarily resident in Assam.
This is under the 6A3 challenge, right?
Yes, but it's actually, it will span both, correct? Because that same expression is used here. But I'll just make the point. Now, if we go to 6A1, you will find, if you just have a look at 6A1, you will find there's a definition as far as Assam is concerned, detected to be a foreigner, specified territory, deemed to be a person deemed to be of Indian origin, and yes, deemed to have been detected. Your lordship sees that? The expressions which are defined. Person ordinarily resident in Assam is not defined. Now this is very, very important for my purposes, because this is really the entire fulcrum on which both the sections and the subsections and the entire scheme operates. And this was my primary grievance, if your lordship recalls in the opening. This whole business of making it persons ordinarily resident in India and compelling everyone to remain there. Well, that's one aspect. But now let's focus on 6A3. Now I ask myself, if you have certain statutes like say FEMA, Income Tax Act, you have notions of residency defined or linked to the number of days. Maybe 182 days, it may be something more, but you have to have a clear definition. It cannot suffer from this type of vagueness, undefined expression, key core provision of resident in India, ordinarily resident in India, person ordinarily resident in Assam. I'm sorry, what does that mean? Is it 1 week? Is it 5 weeks? Is it 6 months? Is it 5 years? Is it 2 years? No yardstick at all provided. And this, according to us, cuts across both subsections. It leaves it completely vague. And in our respectful submission, if we are right, unconstitutionally vague. You see, the vice of extreme vagueness in a situation for a core concept such as this, what does it leave it? What is the guidance given to a foreigners tribunal or anyone else? What is ordinary? This is a question I ask myself. Now, in this regard, actually in both respects, machinery, absence of machinery, as well as for vagueness, we have some guidance to be obtained from a decision of your lordships. Which is it? Yes, this, my lords, I'll just give you the citation very quickly. This is a judgment, yes, of a constitution bench. I'll give you the citation. 69-2 SCC 166. Yeah. Harakchand Ratnachand Banthia versus Union of India. We'll just request the court master to put it up. 69-2 SCC 166. Now, this had to do, and the relevant paragraph I should just indicate is para 21, in the context of renewal of licenses. At page 1, I think it may be at page 1, para 21. It begins with, we now come to section 20. Yes. So I'll just place this, it spans both issues. And it's self-explanatory when I read the para. We now come to section 27 of the Act, which relates to licensing of dealers. It was stated on behalf of the petitioners that the conditions imposed by subsection 6 of section 27 for the grant or renewal of licenses are uncertain, vague, and unintelligible, and consequently wide and unfettered power was conferred upon the statutory authorities in the matter of grant of renewal of license. In our opinion, the contention is well-founded and must be accepted as correct. Section 27(6)(a) states that in the matter of issue of renewal of license, the administrator shall have regard to the number of dealers existing in the region in which the applicant intends to carry on business as a dealer. But the word region is nowhere defined in the Act. Similarly, sections 27(6)(b) requires the administrator to have regard to the anticipated demand as estimated by him for ornaments in that region. The expression anticipated demand is a vague expression which is not capable of objective assessment and is bound to lead to a great deal of uncertainty. Similarly, the expression suitability of the applicant in 27(6)(e) and public interest in 27(6)(g) do not provide any objective standard or norm of guidance. For these reasons, it must be held that clauses so-and-so impose unreasonable restrictions on the fundamental right of the petitioners to carry on their trade and are constitutionally invalid. It was also contended that there was no reason why the condition for renewal of license should be rigorous as the condition for initial grant of license. The requirement of strict condition for the renewal of license renders the entire future of the business of dealers uncertain and subjects it to caprice and arbitrary will of the administrative authorities. There is justification for this argument, and the requirement of section 26 of the Act imposing the same conditions for the renewal of license as for the initial grant appears to be unreasonable. In our opinion, so-and-so are inextricably bound up with the other clauses in section 27(6) and form part of a single scheme. The result is that clauses so-and-so are not severable and the entire section 27(6) must be held invalid. 27(2)(d) of the Act states that the valid license issued by the administrator may contain such conditions, limitations, and restrictions as the administrator may think fit to impose, and different conditions, limitations, or restrictions may be imposed on different classes of dealers. On the face of it, this subsection confers such wide and vague power upon the administrator that it is difficult to limit its scope. In our opinion, 27(2)(d) of the Act must be struck down as unreasonable restriction on the fundamental right of the petitioners to carry on business. It appears, however, to us that if section 27(2)(d) and 27(6), etc. are invalid, the licensing scheme contemplated in the rest of 27 cannot be worked. It is therefore necessary for Parliament to enact fresh legislation, etc. So this is important in the context of vagueness, which your Lordship... Are we going there directly? Yeah. Yes. So this, my lords, I think, at least we feel that this is persuasive on the point that when you have such key concepts which remain completely undefined and open-ended, we are left guessing as to what is the exact contour or parameter of persons, my lords, who are resident, shall be ordinarily resident in India, in Assam, I'm sorry, since the dates of entry, etc. So this is too crucial a concept without any parameter, anything laid out. So anyway, I'm done now with this point. Yes. Now this I should, yes, your Lordship may just note it, that this was followed to strike down 66A in, I'll give you the citation, Shreya Singhal versus Union of India. That's of course a two-judge bench, my lords. 2015, volume 5 SCC, page 1, at paragraphs 55 to 68 and 85, two learned judges. And in Shaira Bano versus Union of India, this aspect is now regarded as a facet of manifest arbitrariness. In Justice Nariman's judgment, 2017, 9 SCC, page 1, paragraph 101. That is, my lords, at index number 163 of volume 5 before your lordship. Shaira Bano is there. So now this is one aspect. Now there's one other parallel, one other aspect which I'll just, since we are on this machinery aspect, I'll just indicate. We have the advantage of a constitution bench judgment in state of Madhya Pradesh versus Baldeo Prasad. The citation is 61, 1 SCR 970. And from the SCC print, it is paragraphs 8 and 9 that are relevant. Oh. Okay, we'll try and get that. It's the paragraph beginning, the section does not provide that. Yeah, further down. Here. Oops. Incidentally. Above this? Yes, just above. Yes, here. Here. The section does not, your lordship has that. Now, I'll just explain this. So this was in the context of the Gunda Act. And the provision was struck down by the High Court, upheld by the Supreme Court, because the definitions were just so completely vague. Now, just two paragraphs. The section does not provide that the district magistrate must first come to a decision that the person against whom he proposes to take action is a Gunda and gives him no guidance or assistance in the said matter. It is true that under Section 4, a Gunda is entitled to have an opportunity to be heard after he is given a copy of the grounds on which the order is proposed to be made against him. But there is no doubt at all, that all the Gunda is entitled to show in response to the notice is to challenge the correctness of the grounds alleged against him. The inquiry does not contemplate an investigation into the question as to whether a person is a gunda or not. The position, therefore, is that the district magistrate can proceed against a person without being required to come to a formal decision as to whether the said person is a gunda or not, and in any event, no opportunity is intended to be given to the person to show cause he is not a gunda. The failure of the section to make a provision in that behalf undoubtedly constitutes a serious infirmity in the scheme. So what we are is trying to draw sustenance in terms of our argument is that providing a machinery for determining and not just issuing a show cause notice to Gunda, you can't, this converse point, namely that, oh, it might be weeded out in a process if and when someone is detected, is not enough. There ought to be, in our respectful submission, I'm
For
sorry.
those who take the benefit of subsection 3, there is a machinery.
For 3, there is a machine.
There is a machinery
There is a
by the explanation. So when
Yes.
you apply
No,
for
there's no
registration-
doubt about that.
Yeah.
There's no doubt about
There is no machinery for.
No,
of
you're right.
subsection
Absolutely.
2.
This is, my machinery argument is confined only
To
insofar as
subsection 2.
2 is concerned, and also to the extent that if you haven't defined a person who is ordinarily resident in Assam, I mean, then what is the inquiry going to be? I mean, it's just completely vague. What machinery can the machinery do also? This is such a crucial concept, my lord. It has to be in some days, numbers, something has to be there. Ordinary resident, it's just otherwise completely.
You have artificial definitions for fiscal legislation, like income tax.
Right.
180 days.
Yes, right.
For FEMA,
Right.
whatever, 270 days.
Yeah.
But these are not, in that sense, fiscal enactments. For the fiscal enactments, it normally will have a very precise definition.
Yeah.
You're conferring citizenship.
Yeah.
So ordinary resident is not, it's not a term of art. It has the ordinary connotation. Somebody who
But how many days? I ask myself.
it won't be, say, ordinary residence for 2 days or ordinary resident for 3 days.
But what is it, 6 months?
You're right. There is no precise definition.
Frankly, Malaj, the law is actually to the contrary. If you with an intention move, so for example, someone like me sort of moved cities and came to Delhi. If a person moves to Delhi and even on day 5, if I've intended to move to Delhi, I would then probably have to describe myself as resident if I pack my bags, etc. at day 2.
Intention to reside.
Yes, but here, therefore, you have a situation, Malaj, please, this is in the context of illegal migrants, Malaj. It's not an ordinary person translocating within the country, etc. And so, having regard to that factual matrix, absent any criteria, any guidance, I believe it is constitutionally infirm in terms of an absence of any definition. So, Manoj, I am now done with this particular aspect as well. Now, I go to my next point. Now, here I wish to draw support from the joint communique. So, I'll just state the point. First, the point is this. The point is neither the... Sorry, one more point, Manoj, in that notion of ordinarily resident in Assam. I'll just make that point and then I'll move to the next one. This is not a concept which we found embedded anywhere, either in the Assam Accord or indeed in the communique. I'll just state that point. So that has no basis at all. That's a creation and a construct. There's no historical basis. There is no commitment in terms of international obligations or anything like that as far as this notion of ordinarily resident in Assam is concerned. Now, Manoj, I'm on the communique. Now, would your lordship please, sorry. Yes, your lordships will find that at serial number 4A, page 9398. And it's at serial number 94.
Volume?
4A. So I'll just state my points quickly on this communique.
4A, page 94.
Yeah. No, Manoj, the page is 9398. Page 9398 of volume 4A.
Yes.
So I have 2 points here. Your lordships have the communique.
Yes.
So if you have page 9398, to just see the second paragraph of the communique, starting with the words during his stay. During his stay, the Prime Minister of Bangladesh addressed a mammoth gathering of people of Calcutta. He expressed gratitude on behalf of the government and people of Bangladesh to the government and people of India, especially to the neighboring states of West Bengal Tripura, Meghalaya, and Assam for the hospitality and assistance given to the millions of Bangladesh citizens and for the moral and material support given by the government and the people of India to the struggle for liberation. And then your lordships will see a further reference to that date, 25th March 1971. That's towards the foot. The Prime Minister of Bangladesh solemnly reaffirmed his resolve to ensure by every means the return of all the refugees who have taken shelter in India since 25th March 1971 and to strive, etc., etc. So I make 2 points. The first point I wish to make is this is not specific to Assam. Well, let's be very clear on that. This communique doesn't single out Assam at all. And I make a second point, which is, in fact, the communique treats the neighboring states of West Bengal, Tripura, Meghalaya, and Assam as a single set of bordering states for which the Prime Minister of Bangladesh also accords his great thanks and extends his thanks to the people of these states. So I believe this supports our submissions in 2 respects. First, this is no justification for singling out Assam. And second, in terms of what was recognized as the impact even then was all these border states. And therefore, this amounts to invidious discrimination and it amounts to an object which is itself by its very nature discriminatory. Now I want to just, there are several other points, but I'm just going point-wise. But I want to just leave a thought with you, and then I'll come back to it. Please consider, if you consider it appropriate, and I'll deal with this in the context, other submissions. I'll just state the point and then cite the decision later. I believe this provision ought to be struck down entirely. That's my case. But please contemplate a prospective invalidation. Think about, I mean, I'm sure your lordships will think about it the moment we make a submission in that regard. But I'm just planting the seed at this point of time. Look, it was mentioned correctly by, I don't know what correctly, but the Solicitor General at least at one point reacted to the observations made by the bench. I'm just saying it was a reaction. Maybe this is in the nature of a transitory provision, etc. But I'm not holding anyone to that particular expression. But surely, when you have no time which is prescribed at all for when you can take advantage of this, and if it were for some historic purpose from 66 to 71, surely it should not continue on the statute book and become a license and become an opportunity, a fertile ground for all sorts of local industries with regard to documentation and things of that sort, and remain on the statute book and remain on an endless beacon only to the state of Assam. So anyway, I've just made that point with regard to this. So I now come to my next submission. It really builds on the point regarding the communique. Territorial classifications we accept are valid classifications. That is a valid method for the legislature to certainly go about its job. We don't question that at all. The issue is it a valid classification here when the problem was for all the border states, when the communique recognized all the border states, when the affidavits which have been filed by the union government also record and their submissions record and accept that this is a huge problem in other states as well, which are just our neighbors, then the question I ask myself is, surely this is a case of impermissible and a discriminatory object of itself, singling out Assam for this. And when it is combined with the notion of ordinarily resident in Assam and continues to be ordinarily resident in Assam, it has impacts across generations and across decades. Now I come to the next point. So I won't take you there, but the Solicitor General correctly went through his written submissions and he pointed out 6 sets of provisions in our constitution itself, which are specific to Assam. So I'll just comment on them because that was the point which was raised. The provisions which are special to Assam in our constitution are in this regard. First, with regard to autonomy and greater autonomy to certain areas, including 6th schedule. That's one type. Second, it is with respect to grants being made by the central government in lieu of export duty on jute. So again, it's something beneficial. Third, it's in respect of general grants in aid to Assam, because there are parts of the country which are found to be necessitating or requiring a leg up. Fourth, there are special provisions by the GST Council for Assam and a number of other enumerated states. There are 6 or 7 states which the Solicitor General fairly placed before you. So it's a group of states where it was felt that the GST Council, etc., has to have special regard with regard to Assam. Then it's with respect to provisions for reservations of scheduled castes and scheduled tribes. And the other special provision is for tribal administration. So broadly, these are special provisions inuring to the benefit of the citizenry of Assam, the people of Assam, and the state of Assam. They are not provisions where you set out one territory and then discriminate in it. When I say discriminate, what I mean is, your lordships have followed. I mean, I'm not saying there were some animus against the state of Assam, not that way. What we are suggesting to the court is, by singling Assam out and then coupling it with ordinarily resident for all times, I mean, it's really a death blow, or it's terrible as far as the demographic and future impacts are concerned. So territorial classification we accept. All the examples given are beneficent for advantages, for certain social good and uplift. I don't believe the present statute fulfills any of those requirements insofar as the citizens of Assam are concerned. Now we have no, yes, I would respectfully submit, there is no instance of any, what I would describe as hostile discrimination. These are all beneficent classifications for Assam. There is no case, at least as which we could find, or no situation where Assam has been singled out for the purposes of something harsh or something which is disadvantageous. I'll say disadvantageous. Now I come to the next point. And the next point is really in terms of, now the reality is that this 6A is only with respect to Assam. So I'm just stating the point. I believe this by itself and nothing further requires heightened scrutiny or strict scrutiny, and not the relaxed scrutiny standard which was commended by the Attorney General. I will just put it at that. Now, please, sorry. Now, please. Sorry. Yes, no problem. Later. Statelessness. Yeah. Now, my lords, I'm on my next point. Now, here, please consider as an alternative submission on our part an appropriate declaration, strictly in the alternative from my standpoint. A declaration that the impugned provision section 6A be declared prospectively to be invalid. And here, I'll just give you the citation. The judgment that we are relying upon is Somaya Organics. Okay. 2001, volume 5, SCC 519. The relevant paragraphs are 23 to 27. Sorry, my mistake, 23 to 37. I'll just read 37, your lordship. I mean, if it's there, well and good. Otherwise, 37. Okay. Yes. Nevertheless, a enacted law without legislative competence remains on the statute book till a court of competent jurisdiction adjudicates thereon and declares it to be void. When the court declares it to be void, it is only then that it can be said to be, it is non-est for all purposes. In synthetics and chemicals, the invalidity of the provisions was a declaration under Article 141 of the Constitution. It was for doing complete justice that the court, in exercise of jurisdiction under Article 142, molded the relief in such a way as to give effect to the declaration prospectively. It is not possible to accept that such an order of prospective overruling is contrary to law. An invalid law has to be held to be, and has not been held to be valid. All that has happened is that the declaration of invalidity of the legislation was directed to take effect from a future date. So this might be, I mean, just if we are wrong with respect to our primary submission, but you feel, or rather, if we are right on the primary submission, but your lordship feels that still there is some molding which is required to be done, then you may consider this. But according to us, it is really unfair to have this continuing on the statute book, because it's not just a one-time issue. It's an abiding impact which continues across generations. Now I come to my next point, because I understood a submission to be made that with regard to culture, there has been no explanation in either the pleadings or in any of our documents as to what it is, etc. So I'm just giving you the paragraph numbers and the page numbers, and I'll just summarize our case. In writ petition 876 of 2014, which your lordship will find at volume 3, volume 3, the averments as far as culture are concerned in great detail are from paragraphs 21 to 34 of the petition. And it's at pages 3010 to 3020. So we've given definitions of culture, international obligations for sorry. Just a minute. Yes, yes. For 682. Yes, that's a, yeah. Yes, it does. Yeah. Yeah. Right. So, but can I just tell you at this distance? So yeah. So may I just respond to that? So I'll just respond to that. The question being put, sorry. Yeah.
Persons who would have not have been included, but still it will open to them to contend that we were there before 66.
Yeah. So I'll
Either
just
that's
answer, but the
factually that's
question,
also possible.
yeah, the question to being, as I understand it, is that is it too late in the day to provide a machinery? insofar as 682 is concerned. That's one, I think, one part of the question. In my respectful submission, at this distance of time, which is 37, 38 years after 1985, that's why we waited to see how are they going to place their case as far as machinery, etc. is concerned. But nobody even suggests that there's a machinery under 682.
Actually,
So I would, sorry.
There's a little bit of a policy determination by Parliament. I think what Parliament seems to have done was that they said prior to 1966,
Yeah.
they gave a very liberalized regime for deeming citizenship. After 66 and
It's the
before
same four
70
criteria.
But between 60, you're right, same criteria.
Same criteria.
But with the addition for 66 to 71
Deemed.
of registration. No registration.
But that's included, Manoj. That's, please see that.
There is no registration requirement for prior to 66.
Sorry? Ha, registration under 63. Ha, yes, yes.
So, therefore, for those
that.
who came in between 66 to 71, they had one specific criterion, namely that you must have been detected as a foreigner. That is, it's like an amnesty. That, first you are detected as a foreigner. If you are not detected as a foreigner, you don't get the benefit. After you're detected as a foreigner, you have to then register. If you have registered, then you get citizenship. That's the scheme for 66 to
Actually,
71.
that is how we understand it as well.
That's right.
Because it was suggested, and just to add to that,
Yeah.
we didn't find any method by which you can make a self-declaration.
You have to be detected as
It
a
has to be detected.
Now, prior to 66, I think there seems to be some sort of a more, should we say, a more relaxed regime which was applied by
What does
Parliament.
it mean?
On the basis that, these were things which happened in the past. They are not going to go out of India. You don't want them to be stateless. They have assimilated for all intents and purposes, because prior to 66 means that 19 years had elapsed even when the law was brought into force. Parliament felt that, all right, now what has happened in the past, let's now freeze it at that.
First, I would respectfully submit that would, sorry.
Prior to 66 or
Yeah, yeah. So just responding to the point, I would be a little more generous to Parliament, in the sense I would suggest that Parliament is certainly providing criteria which are objective. So what I'm suggesting to the court is that I believe it would be correct to interpret this statute as saying that Parliament intended exactly what it mentioned. It didn't want to just hand over citizenships XYZ.
There are those conditions even there.
There are criteria which are there. Now, if you have criteria which are there ought to be a machinery. So what your lordship is saying, there's not even a census. It's not even after this act comes into force that there is a count that at least we are freezing everybody on this day.
There would be a
Not even that.
There would be a machinery under the foreigner's order.
No, there's nothing, my lord. Nothing happened after 1985. We specify so that nobody can really object and say it's criteria less. And then we have no machinery, so it becomes criteria less. And then there's a distance of time, so therefore an argument is advanced that delay and later. So I think we should be.
Now we've,
Yeah, so I'm done with that.
anything
Now,
more?
my lord, yes, no, so I'm just making the point. So now on culture, I was on that aspect.
Culture.
I've given you the pages where we have detailed, we've cited, my lord, various international covenants, etc., with regard to the protection of culture, and based on the census report, because the studies which we placed in our opening were based on the census figures. So 4 impacts: language, religion, land holding, and number 4, self-governance. Because if you're taking away vote, it's a right according to our self-governance. Organizing yourself in a community is all a very, very important aspect of culture. And what is happening here is there is an enormous undermining of the local community by, I will use the expression, non-citizens. So that's the cultural impact which we have, which we believe we have been able to satisfactorily project. None of this has been contested at all. Now I come on to the point, next point, which is with regard to proportionality and the basket of rights. Now, citizenship, as we understand it, I indicated that earlier, is a full-fledged basket of rights recognized under the Constitution, recognized under statutes. One can understand, there are subordinate rights. Those subordinate rights might involve an exclusion of political rights. It might involve an exclusion of certain economic rights.
What is that point? Subordination?
Sorry?
What is the second point?
No, so I'm just suggesting to the court that you have a full basket of rights.
Yes, that gives.
That's one. That's citizenship. But there can be situations. So, for example, let me just give you an example. International humanitarian law requires, there are minimum standards under international humanitarian law. You have to provide that. You can't, but that is short insofar as of citizenship. So, the proportionate response which would be in a situation such as this, if people have come from 1966 or earlier than 66, or because of certain situations and exigencies, such as facing deprivation or facing much more hostile circumstances, then certain minimum international human rights, humanitarian law standards can certainly and ought to be extended. But that is short of citizenship. And therefore, in our respectful submission, 6A fails to narrowly tailor benefits to non-citizens. It is completely disproportionate in what it grants and gives without any meaningful scrutiny. And so the expression used, live and let live, is perhaps consistent with international humanitarian law in the context of illegal migrants, but there is no requirement of conferring citizenship. That is something much higher. And this provision, in doing so, perhaps exceeds permissible limits. Now I go to my next point. So I will just come to statelessness, but just have a look at one provision which was read, which is the Foreigners Act. Sorry, but there are two sections I want to read. First, please just have a look at the Foreigners Act. Section 3, Section 3, it is at page 386 of volume 4, serial number 6. There are just two statutes I want to touch on. Your Lordships have the Foreigners Act 1946, because this was a question.
Mr. Diwan, page is volume 3, page?
386, volume 4, 386. So I'm going to just read this, just read the section. So your Lordships will see what can the central government do, or what is it required to do elsewhere in the country. Your Lordships have Foreigners Act 1946?
Yes.
So if we see section 3, directly, I'll just read this. 3.1, power to make orders. The central government may by order make provision either generally or in respect to all foreigners, or with respect to any particular foreigner, or any prescribed class or description of foreigner, for prohibiting, regulating, or restricting the entry of foreigners into India, or their departure therefrom, or the presence of continued presence therein. In particular, and without prejudice to the generality of the foregoing power, orders may be made under this section that may provide that the foreigner, A, shall not enter India, or shall enter India only at such times and by such routes. B, shall not depart from India, or shall depart only at such time and by such route from such port. Shall not remain in India or in any prescribed areas therein. Shall, if he has been required by order under this section not to remain in India, meet from any resources at his disposal the cost of removal from India. D, shall remove himself to and remain in such area in India as may be prescribed. Shall comply with the conditions as may be prescribed or specified, requiring him to reside in a particular place, imposing any restrictions on his movement, requiring him to furnish such proof of his identity and to report to such particulars to such authority, requiring him to allow his photograph and finger impressions to be taken, requiring him to submit himself to such medical examination, prohibiting him from association with persons, prohibiting him from engaging in activities of a prescribed or specified description, prohibiting him from using or possessing described or specified articles, otherwise regulating the conduct in any particulars as may be prescribed, shall enter into a bond, etc., shall be arrested and detained or confined, and may make provisions for any matter which is or may be prescribed, and for such incidental and supplementary matters. So very wide. Now, this is the regime which applies across India for foreigners. This is their power which they have. And please see subsection 3, any authority prescribed in this behalf may, with respect to any particular foreigner, make orders under clauses E, F of subsection 2, which, as your lordships have seen, includes the removal, requiring a person to reside in a particular place, etc., and to enter into a bond, etc. So now this is the national regime. So they have these powers. And I think the purpose of this section is also to draw the distinction between citizens on the one hand and foreigners on the other hand. So there's a divide, and there is a huge gap, therefore, in lifting up to a citizen. Now, please see the other provision which was read to your lordships is the Immigrants Expulsion from Assam Act 1950. Now, look at this statute. It's at page 424 of volume 4, and it's at serial number 10. Same volume.
Immigrants expulsion from Assam.
1950. The Immigrants Expulsion from Assam Act 1950, which was placed in court.
Page? What page should that be?
424. Volume 4, page 424. Now see the parliamentary mandate here. An act to provide for the expulsion of certain immigrants from Assam, be it enacted by Parliament, short title, the act may be called the Immigrants Expulsion from Assam Act 1950. It extends to the whole of India. Power to order expulsion of certain immigrants. If the central government is of the opinion that any person or class of persons having been ordinarily resident in any place outside India has or have, whether before or after the commencement of this act, come into Assam, and that the stay of such person or class of persons in Assam is detrimental to the interests of the general public of India or any section thereof, or any scheduled tribe in Assam, the central government may, by order, A, direct such person or class of persons to remove himself or themselves from India or Assam within such time and by such route as may be specified, give such further directions in this regard to his removal or the removal from India or Assam as it may consider necessary or expedient. And then the proviso, provided that nothing in this section shall apply to any person who, on account of civil disturbance or fear of such disturbance in any area now forming part of Pakistan, has been displaced from or has left his place of residence in such area and has been subsequently residing in Assam. So I'll just make 2 or 3 submissions. First, where the expression in section 2 is the central government may by order direct the person to remove himself, we would respectfully submit this is a power coupled with duty. That's one point I want to make. So the whole emphasis is that you have a parliamentary statute which is extant for expulsion of people from here. And on the same hand, how do you balance that with section 6A and this open-ended no time limit provision which continues to act as a beacon? So the two really don't stay or can't really sit side by side. And here, if we are correct that this is the act which really should be worked and its main purpose is expulsion, then I would respectfully submit that as far as the proviso is concerned, it has to be given its plain meaning, but it's a narrow exception to the general rule. It's a narrow exception insofar as the general rule is concerned. Yes, and this again, my lords, there's no question, of course, here of conferral of any citizenship. Now, my lords, I just want to point out one part with regard to one other element, and this is in our writ petition. I'll just give you the page number. It is page 3044, volume 3. Now, I am just mentioning this because it came up in the course of your lordship's observations, etc. There's an extract here from Dr. Namrata Goswami, who is an associate fellow at the Institute of Defense Studies and Analysis, New Delhi. And she has written a paper or a study. And there is a quotation here, which is important from a facet which your lordships raised, which is economics. Because the state has limited economic resources, and what is happening as a result of illegal migrants is that there are manifold economic impacts which are recognized here. So the labor law, the labor rates, etc., go down. And the result is that local people don't get as much of a living as they might otherwise. Then there are beneficent schemes which the government of India rolls out, and those resources also get drawn up by persons who ordinarily would not be entitled to it. Now, my lords, I go to my next point, and the next point is with respect to this notion of statelessness. Now, I'll just make 3 or 4 points on statelessness. I gave it. No? Oh, sorry, the whole document is also available. I have to give it.
But that issue, statelessness, doesn't arise here, my lord. It arises in somewhere else.
No, but my lord, they've argued on statelessness, and that has weighed
I have
heavily
not
with your lordships. That I want to just address your lordships on statelessness. I'll just make 4 points or 5 points. First point.
There are other petitions pending on this, my lord. Therefore, I am cautioning my learned friend as a good friend, my lord, that let him not touch this issue. My lord. Nobody has raised it.
No, but it's a concern which your lordship, the argument made is that if you strike down 6A, it will result in statelessness. I'm only meeting that argument and nothing further. I'm not going beyond that. The argument of the respondents was that please don't strike down section 6A. That's how I understood the argument. We will be rendered stateless and there'll be... So I'm just answering that. First point. This argument of statelessness is completely unjustified. And the reason we say so is because, number one, what is the regime which applies across the country other than Assam? Is the question I ask myself. The very same regime which applies across the country doesn't result in statelessness will apply to Assam if we are correct and this provision is struck down. That's number one. Number two, nobody is asking for consequential reliefs in some summary manner. We are only seeking today a suitable and appropriate declaration of the law. The declaration of the law will not result in, by itself, it will just state what it will clarify the correct position in law. What consequential provisions are to be, action is to be taken will follow from that once we have the advantage of your lordship's ruling. But to hold up statelessness and say that, oh, if 6A goes everything, I don't believe that there is any justification at all for that. Now, this takes me to the latest affidavit they have filed. Now, please just go to that affidavit. The new affidavit. Please go to page 2, paragraph 4. I'll just focus on a couple of paragraphs. You may, sorry. Your lordships have the affidavit?
Yes.
So you may just consider on the 7th December order, I think in clause Roman 1, perhaps it should be 6A3. You may, I mean, if you find that as an error, then that just may be.
Mr. Devan, after this affidavit, you will wrap up because then we can use
Yes.
10
No, I'm
to-
wrapping up. Yeah. So I'll just make 2 points over or 3 points. So that correction if you want. Now just see para 4. That with reference to query 1, namely the number of persons to whom citizenship has been granted under the proviso to 6A, I think it should be 3, namely persons who came to Assam between 66 and 71, it's humbly submitted 17,861. Your lordship has that figure. And the next figure is, which is that the foreigner, that with reference to the query, how many persons have been detected to be foreigners by an order of the Foreigners Tribunal under the Foreigners so-and-so Order 64 between 66 and 71, the answer is 32,381. So the first issue, which I'm just stating the point, is what happened with regard to 32,381 less 17,861. So that works out to 14,520 persons. So they must inform the court as to what is the action which has been taken in respect of these 14,520 persons, because these people are found not to be entitled to any right even under 6A3. So I would respectfully submit. So this is one important point which your lordships will consider. What is the action taken with regard to that? And then please see 6AA, para 6A. Illegal migrants enter into the country without valid travel documents in a clandestine and surreptitious manner. The detection, detention, and deportation of such illegally staying foreign nationals is complex and an ongoing process. So when your lordships asked them for the estimated flow, this was the answer. Now, the bottom line is, there is no authentic information with regard to when the 1985 Act came, who is going to benefit or how many are going to benefit under 6A2. There is no authentic figure even in respect of 6A3 because it is open-ended in terms of time. And we would respectfully submit that insofar as the notion of statelessness is concerned, it is just being raised without, because we ourselves say that as far as international humanitarian law is concerned and that proportionate response is concerned, that's the obligation of the state. We are not for a moment seeking to prejudice anyone in that behalf. Now, Manoj, I'm on my last point. And the last point is with regard to delay and leaches. Now, I'll just very, very briefly tell your lordships 3 or 4 issues. First, you will find the reference order itself has gone into this issue inter partes. That's one. And I said that we are entertaining this petition. So it's inter partes between the same parties that a determination has been made by this court. So we're not sitting in appeal over that judgment in the very same case. So that should bind. But the reference court left it open to your lordships to mold the relief appropriately. So that's my first point. My second respectful point is that if they accept, as they do, that this provision continues to operate and even tomorrow you can go and apply under 6A2 and 6A3, then in our respectful submission, there's no question of delay and leaches because it's continuing in every respect. My third respectful submission is that you have a situation now which is the aspect regarding culture, community, economic rights, which extends generation upon generation. So it serves and deserves to be struck down, if we are correct. Even today, to protect what is left, despite this huge onslaught on our cultural and community rights. I'm very grateful. Thank you.
Thank you, Mr. Devan.
Wait, please, Your Lordships. My Lord, the first point I would like to deal with is regarding the delay, my Lord. On the point of delay, my Lord, as my learned friend Mr. Diwan has pointed out, my Lord, in para 31 of the referral judgment, my Lord, virtually, my Lord, this point has been rejected. And I'm sure this is not Lordship is not sitting in appeal over the reference court's order. Therefore, my Lord, as far as the issue of delay is concerned, that stands at rest. Yes, the reference court did frame one issue, my Lord, in view of the fact that these beneficiaries have enjoyed certain rights over a long period of time. Therefore, what view this honorable court should take at this stage? In other words, my Lord, it is in the relief more of, my Lord, molding of relief than to non-suit the petitioners, as the other side would like to contend. Therefore, my Lord, in my written argument, my Lord, I think at page 29, I have dealt with this issue, my Lord, in details, my Lord. I may indicate, my Lord, which are the pages.
That's all right. You've told us earlier. We'll find it out.
My Lord.
Just summarize
Just-
now what you want to say.
Yes, my Lord. Lord, kindly give me 15 minutes time, my Lord. My Lord, page 29 to 32 of my written argument of volume 1, my Lord. Now, my Lord, the government's affidavit, which they have filed, my Lord, government is trying to give an impression that what we are agitating is a trivial issue. It's a matter of 30,000 or not the business. So what is great in it, my Lord? With all respect, I'll submit, my Lord. Is it the case of the government? They're construing this litigation to be an adversarial litigation, where, my Lord, millions of, my Lord, immigrants are in the state, where the local people have been outnumbered, and government would still like to go by legalism. With great respect, my Lord, this cannot be the correct position, my Lord. Now, my Lord, yes, it is a fact. It is very difficult to make approximation as to what is the exact extent of immigration which has taken place. That's very difficult, my Lord. The white paper published by the government of Assam also expressed the same difficulty. But, my Lord, there are contemporaneous facts from which one can come to the conclusion that this immigration is of substantial, and, my Lord, it has caused change of demographic profile and other adverse effects, my Lord. First, my Lord, I would like to place, for your Lordship's kind consideration, in the rejoinder submission, my Lord, I have volume 1A, my Lord. If your Lordships will kindly come to page number 3.
Why don't you do this like Mr. Diwan had formulated? In fact, I've taken
No,
down
I'm formulating.
14 submissions of Mr. Diwan. Now you just formulate point and then tell us what
No, my
because
lord.
we are now in rejoinder.
No, I know, my Lord. What I'm trying to say,
So first is
my Lord,
delay.
while opening also, my Lord, I couldn't get much of time.
So delay, you have said that, the reference judgment para 31, volume 1, pages 29 to 33.
I have dealt with that issue, my
All
Lord.
right. Now what is the second submission?
My second submission is, my Lord, I'm trying to, my Lord, take a stand against the affidavit filed by the government.
So tell us the submission, formulate it now.
The submission formulate is, my Lord, the extent of immigration is much more, my Lord, than 32,000, the figure which has been reflected in the affidavit. So, in this regard, my Lord,
But that
Well-
really doesn't affect the validity of section 6A.
what I'm saying,
Because assuming that the immigration is not 32,000 but 3,20,000 or 32 lakhs, the number of persons who are granted citizenship doesn't vary.
it has a bearing, my Lord, according to us, subject to what your Lordships may say.
Yes.
I'm coming to that. I'll come to the Parliament's
Alright,
plenary
extent
power
of
also, my Lord. What are the limitations of that also?
All right, extent of immigration is more than 32,381.
No, much more, my Lord. It is much, much more.
All right, what is the next?
No, my lord, I'd like to place two paragraphs. Kindly permit me at page 3 of my volume 1A, my lord.
Volume
1A
Volume 1A,
of the rejoinder submission.
para,
My lord, is second subpara 2,
page.
page 3, my lord.
So what is the point you make that? Don't read
Point
it out.
I'm trying to make is the Law Commission in its 175th, report on amendment of the Citizenship Bill, my lord, 2000 said that the immigration is of such an extent that it has the potential of, disturbing the unity and integrity of the country. It poses serious security threat to our democracy.
But are you saying that the number of persons who are granted citizenship under Section 6A
Yes,
is more than 17,000?
millions, my lord. It will be more than millions.
How can that be?
My lord,
You
my
are
lord,
confusing.
as far as
Conflating persons who are illegal immigrants with those who have been granted the benefit of citizenship between 66 and 71.
no, my lord, regarding the first batch of from up to 1166,
Right.
then there's a second batch where only they would be, my lord, defranchised for 10 years after they follow the procedure.
Right.
That's the position.
Right.
And my lord, after 25/3/71, these people are to be deported in accordance with law. That is what the, my lord, accord is all about, and that is what Section 6A is all about. Now, my lord, by conferring citizenship to this stream of people, my lord.
The first batch.
Yes. My lord, security of our country has been endangered. That is what Law Commission says. That is what, my lord, the group of ministers also says. I'm trying to rely on those, reports of the government of India. So, my lord, Law Commission clearly says, Law Commission noted that entry of if your lordships will kindly.
You said says that there's a potential to disturb the integrity and security of India.
Yes.
Well, it was
And that was an aspect which was taken note of it.
What's the next
And the
point?
next point is, my lord, after the Kargil war, the then Prime Minister of India constituted a committee or a group of ministers,
That's
my
not a
lord.
point. That's material. What is the point that you're
The
making?
point which I'm trying to make is, my lord, the recommendation or the report of the committee reveals that there are, my lord, 12 million foreigners in northeastern India. And the report reads like this, my lord. If your
Where is the
lordship-
report?
At page 3 of volume 1A. Report is at the report is at, my lord, page 3 to
Mr. Chaudhary and Mr. Hansaria, we are not going to extend hearing beyond 4 o'clock today.
yes.
Today we close.
My lord.
Whoever has not finished, whoever has finished, there's a guillotine at 4 o'clock today.
Yes. No, my lord.
So no, this will not spill over to tomorrow because we have another CB tomorrow.
My-
So you've got about 34 minutes between the two of you.
Yes.
So you please ration time and
My lord,
between.
we'll
Yes.
share amongst us.
No, the last batsman can hit a first ball 6, you see.
No, my lord. No, my lord, run
The others are scared
required.
they'll get. The others are scared of getting out, so they don't try to hit a first ball 6. The last batsman knows that he can hit a 6 and there's nothing to lose.
The run required is 45 and only 2 overs is remaining. It's a difficult task. Anyway, my lord. My lord, the report is at page 3242 to 3351 of volume 4.
3242.
To 3351 of volume 4.
All right.
It was headed by the then Home Minister of the country, my lord. And the relevant report which I would like to read, my lord, is para 2.35 at page 3254.
Para
2.35
at
page 3254.
All right.
And just a small paragraph.
Just tell us what
Yes.
it said. Don't read out. Just tell us, make the point. We'll
It
read
says,
later.
my lord, there are estimated to be about 12 million foreigners in Northeast. A host of problem has been created, including, my lord, economic, political, communal tensions, ethnic clashes. And one very significant observation regarding Assam was, my lord, 32% of the constituencies in Assam are dominated by these illegal immigrants. That means out of 126, 46. Their vote is decisive in 46.
One 26 constituencies, no?
Out of 126, my lord.
46.
32 makes it 40 point something. So it's 40. So therefore, my lord, in my humble submission, figures do matter.
All right. What's the next point?
Yes. Now, my lord, my friend Mr. Sival has mostly covered the points, my lord. Therefore, I will not repeat. I would like to emphasize on a particular point, my lord.
Yes.
What is the scope of Parliament's plenary power? Are we to understand it admits of no limitation?
Just formulate it so we
The
can.
formulation is, my lord, the plenary power of the Parliament, its scope and limitations.
You say, according to the plenary power of Parliament, is subject to limitation.
Yes, my lord.
Of course it is.
Yes. Now, my lord, from the facts which I have referred just now, my lord, what emanates according to us, my lord, subject to what your lordships may say, that making of this classification and creating this class of deemed citizens is posing security threat to this country.
That we've already said.
Yes. Therefore, my lord, as per the decision of the Honorable Supreme Court in Indira Nehru case, my lord, versus Rajnarayan, where Honorable Supreme Court says that amongst others, my lord, supremacy of the Constitution and unity and integrity of the country are also basic features of the Constitution.
All right.
Now, if granting of or conferring deemed citizenship to this class of persons, my lord, it poses security threat, is the object of the legislation not unlawful? Therefore, would the Parliament's power be not fettered by, my lord, the constitutional inhibition of violation of doctrine of, my lord, basic feature?
Yes.
Therefore,
Yes, Mr. Dev.
my lord, in R.C. Podwal's case,
Formulation. What is
Yes.
the formulation?
now the formulation is, my lord, classification has resulted in creation of a class of citizen who pose security threat, which in turn would impair the nation's unity and integrity.
That point you've already made.
Yes. Now, my lord, here, my lord, I would like to refer on the judgment of the Supreme Court, of this Honorable Court, in R.C. Podwal's case, my lord. In R.C. Podwal's case, my lord, the question which arose was,
Bhutia lectures.
yes, what is the, the non-obstante clause,
So they have 20% of the population, they had reservation of 38% of the seats.
and
in
one of
Assam.
the one person, one vote, that principle was also, my lord,
But
done
that
away
was,
with.
that was rejected by
Yes.
Chief Justice Venkatachala's judgment.
Yes, madam. No, what I'm trying to say is, I'm relying on paragraph 102, 175, and 176. 102 is by majority, my lord, and 176 is by Honorable Justice Agarwal, my lord. Now, what I'm trying to, submit for Lordship's kind consideration is the meaning of that non-obstante clause was, laid down, my lord. Now, issue was whether in view of the non-obstante clause, while exercising power under clause F, they can undo the constitutional inhibition, my lord. There, this honorable court said, my lord, that no. Yes, the non-obstante clause would permit you to undo some of the constitutional provisions, but if it goes to the extent of overreaching or overriding the basic features theory, then it will be bad. Now, what I'm trying to, the support which I seek to draw from the judgment is, my lord, by conferring citizenship right
Yes.
to this section of deemed citizens, my lord, the security and integrity of the country has been endangered. Therefore,
You made this point 3 times, Mr.
no, therefore the object of the legislation is, my lord, something which cannot be countenanced.
Thank you, Mr. Jod.
Just one more point.
At 3:18, you said 15 minutes. It's now 3:34. So you've got 1 minute now. Almost 3:35 now.
All right, finally, my lord, I'll just urge one more point, my lord. Government of India very candidly says, my lord, that as far as the allegations we have brought out in the petition or the averments which were made in the petition regarding, my lord, the adverse effect of illegal immigration, they accept it. Now, is it not the government of India to do something, my lord? What have they done? While opening my argument, my lord, I made a submission based on Article 355 that it is the duty of the central government to protect the interest of the indigenous people of the state. I also would recollect, while upholding Armed Forces Special Power Act, this honorable court had taken the view that Article 355 enables framing of a statute like, my lord, Armed Forces Special Power Act, where a non-commissioned officer, even a junior commissioned officer can, my lord, without warrant, even act in case of a non-cognizant.
According to you, government has not done anything.
Anything.
It accepts the impact of illegal
Yes,
immigration.
therefore they can't, my lord, accept the thing and at the same time not do anything. And on the contrary, coming up with these figures, my lord, to show as if it's a trivial issue. It's not a trivial issue, my lord. It's a very serious matter. Finally, my lord, I'll make one submission for Lordship's kind consideration.
But actually,
In the event,
they have not said that illegal immigration is a trivial issue. They are in fact saying it is a very serious issue. But they say that we can't give you an estimate. It is so large. I mean, and it's impossible to give you an estimate because they are all people who are clandestinely and surreptitiously in India.
if that is the position, absolutely correct, my lord. There's no difficulty.
That they're right also because they are not disputing the fact that it's a very serious problem.
Yes. And Lordship, as I have already submitted, Lordship will also consider the aspect.
Nor are we for a moment even suggesting it's not a serious problem. Undoubtedly it is.
In that case, they ought to come up with a more stringent law as to how to deal with these foreigners instead of conferring them citizenship, my lord. It's an unheard of concept anywhere in the world. Where, my lord, own citizens are at the risk of losing their identity. They are protecting the, my lord, foreigners, don't protect
That point you have made.
Yes. Now, finally, my lord, having regard to the lapse of time, the numbers, we all appreciate, my lord, the practical difficulties. In the event your lordship is inclined to take the view that will not strike down 6A, there my submission would be, my lord, let the post 19,748 stream of people be identified and let them be, my lord, relocated in these different states on pro rata basis. Why Assam alone should, absorb this disproportionate burden?
Even if Section 6A is not struck down, the post
748,
1971.
yes, stream of people should be identified by undertaking an exercise like NRC, and my lord, relocate them to different states on pro rata basis across the country. If there is an humanitarian angle, if there is an Article 21 obligation, certainly these measures can be certainly adopted by the state, my lord. Why Assam is a very small state, my lord? The land mass is also very less compared to other big states.
We'll consider.
So therefore, my lord, why not? They should also on pro rata basis,
we'll
they should
consider.
be, relocated in the other parts of the state.
Yes, Mr. Ansaria, thank you.
Biplab.
Let me start with the disadvantage being the last investment, my lord. Lord, before I formulate, my lord, the Chief Justice asked a very pertinent question to Mr. Diwan. When he was arguing clause 2, deemed section, my lord, Lordship said the Constitution also provides Article 6, a deemed provision. Section 6A2, clause 2 says, my lord, deemed if it before 1/1/1966, no exercise is necessary. My lord, the Chief Justice said there is a Constitution also provided deemed fiction under Article 6, my lord. Would your Lordship kindly see, my lord, Article 6 for a minute, my lord. It has limitations, my lord. If your Lordship see, my lord, Article, just give me mine. The Lordship, give me, not mine. Yes, sorry. There is some. If your Lordship see section Article 6, my lord, A, Article 6B2, which gives citizenship, my lord, to the persons who have migrated after 19 July 48. There are 4 criteria, my lord. Because, my lord, here also they are giving citizenship to the persons who have come after 19 July 48. They have to be registered as a citizen. They have to make an application. They have to make that application before the commencement of the Constitution, before 26 January 1950. And they have to be in India 6 months before. None of these conditions are there in clause 2, my lord, of 6A. It's open-ended. Mr. Diwan, I said it's open-ended. Today also I say, my lord, I came before 1966. Constitution Article 6B2 does not permit that, Lord. You have to make the application before 26 January 1950. And you have to make an application. That application, Lord, so there's a fundamental distinction between clause 2 of section 6A and Article 6B2 of the Constitution, Lord.
6B2 came in because there was a permit system, as Dr. Ambedkar said.
Here also, that's what I'm saying, Lord. Here also, so far as 6.3 is concerned.
On 19 July 1948.
I'm coming to that.
It's a product of.
Lord, that's what I'm saying. 6A3 says you have to apply. But so far as 2 is concerned, my lord, you are shifting the date, my lord. My first argument that you are shifting the date from 19 July 48 to, my lord, the 1st January 1966 by this legislation, my lord. You can do a 368 route. This argument will not be available to me, my lord. But by parliamentary legislation, you are shifting the date from 19 July 48 to 1st January 1966. And without those riders, which are there, you're making it open-ended. Even today, wherever there is, there was a time limit of 26 January 1950. Make an application so that people can authenticate, on that day. So that's a fundamental distinction, which my lord, the Chief Justice pointed out, And my submission is that 6A2 and Article 6 has a completely different scheme.
All right, then.
My lord, with this, may I just respectfully submit that draft constitution contained Article 5 and 6 only, which translated into Article 5, 9, and 11. It did not have Article 6, 7, 8, and 10, which were introduced during the debate by Sri Ambedkar, Dr. Ambedkar, on 10th August 1949, by way of 5A, 5AA, 5B, and 5C. And the debates which my learned solicitor read, in my respectful submission relate to the draft articles 5 and 6. There's a different debate and expression of opinion by all the 3 learned eminent members of the Constituent Assembly on 5A, 5AA, 5B, and 5C. And my lord, our is not regarding 5A and 5AA, which is Article 6 and 7. If your lordship kindly see that, lord, it contains a complete code. I'll invite your lordship's attention.
Mr.
Yes.
What is the?
No, my submission is, my lord, that the submission of the central government, the learned solicitor, that the parliament was given due leverage to extend and amend under Article 11 does not apply to the persons who come under 6 and 7, that is the migration from Pakistan. And there is a clear distinction drawn by all the three eminent members of the Constituent Assembly in the debate. And I'll show to your lordship, it's from the debate only, my lord. What has been read to your lordship, my lord, relate to general powers of the parliament, no dispute. But not, my lord, those were covered by Article 6 and 6(7), which is Article 5A and 5B draft constitution. Would your lordship now kindly see, my lord, in this preface, volume 4, the debates, my lord, page 887.
You've made that point.
No, my lord, would your lordship, my
No,
lord,
you've made the
please permit me to read
We'll
that.
not read
It
now.
goes,
No, we are at the.
No, my lord. My lord.
Mr. Hansaria.
yes, my lord.
You must understand, you are in a rejoinder.
My lord, I'm in the
Meeting
rejoinder, meeting the argument of the learned,
You made the point in your opening
my lord,
that look, these people, you have taken 25th March 1971.
my lord.
On 25th March 1971, they were citizens of undivided Pakistan.
They were the
The
Pakistan.
liberation takes place much later.
Yes,
Therefore, you can't confer on citizens of Pakistan any provision which is beneficial by virtue of the power under Article 11A, under Article 11, which is at variance with the
Article
date of
6 and
19
7.
July
my lord,
1948.
what I'm saying is, I'm
Because
meeting the
19
argument.
July, according to Article 6, is comprehensive in its
I
sweep
want- I
and
want-
coverage of those who
Please,
emanated
sir.
from Pakistan.
I want to show that from the speeches made by the learned three eminent authors, my lord,
Well, have you
because,
put
my lord, the argument,
Have you
the
put
reason,
it,
my lord,
have you put it in your written submission?
my lord, I have, my lord, may I just,
They take it as
My
read,
lord,
we will read it later.
my lord, may I just say this, my lord,
Why
I'm not,
don't you go to the next point?
my lord,
and
I will
understand
not
the
be doing
point?
justice to, my lord, my brief and
It's all right,
people-
don't worry, we
people
are
of-
here to do justice.
My lord, may I just say,
You
would your
now
lordship,
to the
my lord,
next point
this is
now.
my lord, main submission. Would your lordship just permit me to show 2 or 3 things, my lord? Because the submission has been made by the learned solicitor that the due latitude were given by the, and from the speeches made by the Dr. Ambedkar, Alladi Swami, and my lord,
Constituent Assembly debate,
My lord, would your lordship-
we can't control the language of the provisions. But we got your point. You made that point right in the opening, that Article 11 cannot give leverage to Parliament to expand on the ambit of those who are granted citizenship by Article
and that
6
is
and
what,
7.
my lord, the founding,
And that's what they have
my lord,
done.
that is what the
It's a point
founding
which you have to
fathers said,
consider.
my lord, in the debate.
But we have to, it's a point worth considering. We'll consider it.
My lord,
We'll reflect on it.
I'm no doubt about that. My lord, what I'm trying to say, my lord, when extensively debates were read to your lordship, my lord, it was said the parliament has been given complete leverage, my lord. The 3, my lord, eminent speakers, Dr. Ambedkar, Alladi Krishnaswamy and Kunzuru's statements were read to your lordship. I want to read, my lord, they were in the context of Article 5, 9 and 11, not in the context of, my lord, 6 and 7, which are draft article.
All right.
My lord, they specifically said, my
We have
lord,
noted it now.
We have noted, we will read.
my lord, may I just give the page number then?
Now just give us
Very-
the page number.
May I give the page numbers? Well, Dr. Ambedkar's speech starts from volume 4, page 887. Regarding this, my lord, Article 5A and 5AA is, my lord, at page 892 and 893. In which, my lord, may I just
All right.
only,
Now, just give us Dr. Then,
Lord, Dr.
Sir
Ambedkar.
Aladi.
my lord, Dr. Ambedkar said on 5A and 5AA at page 890
All
and
right, you made your
893.
point. Just give us
And
Sir
just one
Aladi.
sentence, my lord.
Just give us Sir Aladi's reference.
Aladi question from me, IR, my lord. The relevant, it starts at 953 on the same volume, which is on 12th August. 953 start, the relevant is 955.
All right.
And Pandit Kunzuru's speech starts from 961. What is read to your lordship is 961. And the relevant on this 5A and 5AA is 962 and 964. And my lord, he clearly says this is extraordinary provision, nowhere available in the world. We are making it for an extraordinary situation like this has happened, and up to 1948 only. My lord, can the parliament extend the date, my lord, from 1948 to 66 or to 71? And all the three learned speakers, my lord, who are founding fathers, and they're the heart and soul of the entire constitution which they made, my lord.
All right,
have-
you've made your point. Now, what is the next point?
My lord, I think, my lord, if a lordship, my lord, I will cut short another point. Let me read 1 or 2 paragraphs from this, my lord.
All right, read your point. You're 12 minutes short of rising time. you can mention.
I will try to do, my lord, I say the handicap of the last batsman, my lord. 962 to 964, yes, my lord.
Yes.
My lord, may I just read 955 for a minute, my lord? (955), volume 4, my lord. This is Alari Krishna Swami IRS explaining 5A.
Yes.
5A is intended to provide for all cases of this mass migration, if I may use that expression, from Pakistan into India, and to provide for that class of persons who have made the present India as their home. I'll skip to that note. Certain safeguards are provided for clause 2, so as to make it quite clear that the authorities cannot accept migrated people as bona fide citizens of this country. That is the object of the clause. This is the provision to the effect that no registration shall be made. Similarly, it requires a registration as shown to a lordship, Article 6(2)(b), B2. Unless the person making the application resided in the territory of India for 6 months. So there are 2 safeguards. There will be registration, there will be no registration unless the applicant has resided in the territory for 6 months. If 5A stood by itself, it would mean that even if person went to Pakistan with deliberate intention of making Pakistan as their permanent home and remigrate to India, they might be entitled to 5A. In order to provide such a contingency, 5A is provided, then quoted, which is now my lord 6 proviso. There is no 7. There is no use of dealing with the subject if a person is deliberately and intensely chosen to be a citizen of another country. After question has arisen, after Pakistan has been declared territory independent from India, then there is no point in conceding the citizenship to such a person. But this proviso takes note of this important aspect, etc., etc. So, my lord, clearly deals with, my lord, what is to be, my lord, these are the extraordinary provisions, my lord, which has been said. And 962, my lord, Pandit Kunjru says, last 3 lines of 962 and 963. Now, 962, my lords, which we can kindly go. Last paragraph. Now I shall come to Article 5A. In this article has happened occupying the intention of the members since yesterday. It has been criticized on the ground that provisions undesirable, wide soul, open to the doors of citizens who have no moral right to be regarded. I do not personally agree. Because, let us consider calmly what 5A, that is Article 6, lays down, and the circumstances which require that such an article should form part of our constitution. Article 5A and 5AA, that is Article 6 and 7, contain extraordinary provisions arising out of the present extraordinary circumstances, arising out of extraordinary situation created by the partition of India. You will find no counterpart to them in the constitution of any other country. Then, my lord, they say that there are conditions which are prescribed. Now, my lord, section 6A does away with all the conditions, my lord, with the founding fathers tried to justify for 6 and 7, Article 6 and 7. So far as pre-66 is concerned, no condition, no requirement, which the founding fathers thought even 48 requires, my lord, and 50 requires. So, my lord, to say that, my lord, the founding father gave untrammeled power to the parliament to make law under 11 is not correct, my lord. These observations does not apply, or the statement does not apply to the extraordinary provision made under 6 and 7. That's my first submission, my lord. Second, my lord, lordship would kindly see the constitution, my lord. Article 7 starts with the non-obstant clause against 5 and 6. Article 7 says, notwithstanding 5 and 6, and 6 says, notwithstanding 5. So 7 takes precedence, my lord, and then 6, then 5. If a lordship kindly see that, my lord.
Yes.
So, my lord, if 7 is to be given precedence that fixes the cutoff date as 1st March 1947. So anybody who has come to India, my lord, after going to Pakistan, after 1st March 1947, he does not get citizenship. Under 6, my lord, he gets a citizenship up to 48. And thereafter, my lord, he has to go by the registration and application, etc., etc. Now, my lord, the section 6A, 2 and 3. Mr. Diwan is there. So far as 2 is concerned, there are four requirements, my lord. And unending requirements. Even today, there is no cutoff required date, my lord, for that. 6A3 requires 2 more conditions, my lord. That is, he must be detected to be a foreigner by the Foreigners Tribunal, and he must apply for registration. Now, would your lordship kindly consider it, my lord, saying that as per the affidavit of the government of India, 30,000 and odd has been detected to be foreigner till date. So it must, my lord, it cannot be open-ended. It must confine to those 30,000 and 30,000 alone. It cannot be, my lord, millions. But till after, in case your lordship is to held, my lord, 6A to be valid. My submission is, my lord, the 4 conditions which Mr. Sivan has said. And that is what I have said in my rejoinder submissions, my lord, which is circulated to your lordship, my lord. Those 4 conditions, plus he must be declared as a foreigner, my lord, by the Foreigners Tribunal, plus he must make an application, and this must be confined to the 30,000 people, my lord, because till today, my lord, 30,000 people has only been detected to be foreigner. Can it be said after 100 years, my lord, it become 3 million? Would your lordship kindly see, my lord, that written submission of mine, my lord, which you have circulated today, and in paragraph 9, my lord. Paragraph 9. Just 1 second, just a minute. Para 3. If they have not been detected till date, my lord, where is the question of granting them citizenship, my lord, up to the millions of people? As Mr. Chaudhary has said, my lord, it may be, it is an apprehension, it has happened. So lordship would confine in your judgment, my lord. That's what would your lordship kindly see, my lord, para 3 of my rejoinder submission circulated today, which is there before your lordship screen, my lord. Six conditions. Right. Para 9, para 3 and para 9. Which says not the 6 conditions are mentioned in para 9. And my lord, I have submitted that thus the grant of citizenship to the person entering India after 1948 must comply with the mandatory condition. It is submitted that the section 6A2 required expressly, and my lord, the government of India said 30,000, so it must be confined to those 30,000 people and not beyond, my lord. That's our submission before lordship, my lord. Next submission before lordship is, my lord, plenary attorney general, they have the plenary power, my lord. No doubt they have the plenary power, but it is not, my lord, if your lordship contradict this, my lord, see this article 4.2 for a minute, my lord, and contrast it with article 11. 4.2 says, my lord, no law made under 4.1 shall be deemed to a amendment to the constitution. But article 11 does not say so, my lord. So whatever law you made under article 11 or 246 entry 1, entry 11, my lord, must be consistent with other provisions of the constitution, which would include 6, 7, article 14, etc., my lord. And there are 10 provisions, my lord, of the nature of article 4.2. If your lordship kindly see article 4.2 for a minute, my lord. It says, my lord, no such law as aforesaid shall be deemed to be an amendment to this constitution for the purpose of article 368. For a minute, my lord, kindly lordship may kindly see. And my lord, there are such 10 provisions, my lord, which is in my written submission. Paragraph main written submissions, my lord, volume 1, page 146, your lordship would find. There are 10 provisions in the constitution which says law made under this foregoing provision shall not be deemed to be an amendment to the constitution. And that's not, my lord. So if you cannot amend, my lord, the constitution by this circuitous method, in your lordship's yesterday's judgment, 370, paragraph 390, my lord, the Chief Justice has said, my lord, you cannot use 367 method to change 370. This is the same thing, my lord. You cannot use the circuitous method of a parliamentary legislation to amend the constitution, which we can do only under 368 route, not the 346 route, my lord. So that's my next submission before lordship, my lord, for your lordship's consideration. Just, huh? And my lord, Lord, I initially submitted, my Lord, that the persons who get citizenship under section 6 and 7, 5, 6, my Lord, they must take an oath of allegiance to the Constitution of India. So far as 6A is concerned, my Lord, there is no such requirement of oath of allegiance. And they come from a, my Lord, a country in which it is recognized Islam is the Islamic country of Pakistan. My Lord, in my written submissions, I have said, my Lord, in case your Lordship is to held that 6A is valid, any person, my Lord, even those 30,000 person or 70,000 person, they must subscribe an oath in the form of Schedule 2. And also, my Lord, they must say, if your Lordship kindly see my written submissions, my Lord, in this rejoinder written submissions, para 8, my Lord, Lordship may kindly make a note, my Lord. In para 8, I say that there is no answer to the oath of allegiance. And, my Lord, Rule 19.2 and Form 18, under which they make an application, my Lord. If your Lordship see that, my Lord.
Yes,
Have I, my Lord? I have another 2 minutes, my Lord.
yes.
I have another 3 balls to play. Lord, para 8 of my rejoinder submissions,
Yes.
I have noted, my Lord, under Rule 19.2 of the Citizenship Rule and Form 18 of the Citizenship Rule, they are required to make an application. In that application, Lordship would read it, my Lord. They must subscribe in oath in some second schedule to the Citizenship Act. They must additionally say, I believe in the secularism and I will uphold the unity and integrity of India. That's a very serious concern of us, my Lord. So those conditions, Lordship would incorporate that in case your Lordship were to held, my Lord, it is constitutionally valid. And finally, my Lord, the note by the Government of India says there are 100 tribunals, my Lord, and there are 96,000 cases. That means, my Lord, there are 1,000 cases per tribunal. We do not know how many years it will take, my Lord, to decide those cases. Just to your Lordship's, my Lord, note factually, 200 tribunals were constituted, my Lord, on 6/2/2020.
Sorry, how, 26?
6th of February 2020, 200 additional tribunals were constituted, my Lord, by the Government of India to decide these cases. But they were discontinued on, my Lord, 14th October 2022. I have that order of the Government of India, my Lord. 14th October 2022, all these 200 tribunals were discontinued, saying that there is no sufficient work. And in fact, I must point it out, some of the members of the tribunal filed a writ petition before Lordship, and my Lord, the Chief Justice said, my Lord, this is not a public interest litigation. Your term was under a contract, so you cannot go beyond that. And Lordship said that in case it is there, my Lord, then it will be considered in accordance with law. So what I'm saying, your Lordship, in case your Lordship were to held against me, there are only 100 tribunals. 200 tribunals were constituted. They were discontinued on 14th October 2022. They have to be, Lord, all these cases to be decided fast, my Lord. It cannot be remain for another 5 years, 10 years, my Lord, these cases will pending.
Lord,
So
may I
those
take
tribunals.
1 minute, my Lord. One important judgment is missed, my Lord.
Yes.
It's under 6A, therefore, my Lord, it's necessary for me to cite. Volume 5, page 5238, the relevant part. My Lord, 6, it starts at, my Lord, 5226. It was concerned, my Lord, that I would be missing, my Lord, if I don't cite this. Since Mr. Diwan cited, my Lord, this ordinary resident is not defined. In rejoinder, my Lord, I did not cite it. It's on record, my Lord. 6A2, my Lord, your Lordships have, my Lord, page 65238, or I may read.
5238.
38.
Yes, give us the citation.
Yes, my Lord, it's 1994, supplementary 1 SCC, page 615. Paragraph is 62. Please read, it's a short, my Lord, 5-line paragraph under 6A subsection 2. I'm sorry, condition number 2 of 6A. But 5238, my Lords. My Lord, may I read para 62? Turning to condition number 2, the requirement is ordinarily resident in Assam from the date of entry till the incorporation of section 6A, namely December 7, 1985. As to the meaning of ordinary resident, we may refer to Shanno Devi versus so-and-so. This is a constitution bench. We find the following observations at page 590 apposite. It is not necessary that for every day of this period, he should have resided in India. In absence of the definition of the words ordinarily resident in the constitution, it is reasonable to take the words to mean resident during this period without any serious blame. That's it.
Anything else? Thank you.
I'm extremely grateful, my lord.
We have
My lord, in
heard so
in the
and so.
rejoinder submissions, my lord, because I had
You can
very,
spend-
I had very limited time in the rejoinder submissions, my lord, whatever I have said, my lord,
Certainly.
while today are there, my lord, before lots,
Certainly.
lots of.
Thank you, everyone. Thank
Grateful
you.
to all.
We're extremely grateful to your lordship.
Yes. That has to be
It was to
detagged.
be de-tagged, Manoj, that's why, yes.
That, detag that. एक बार check कर लो, please. Not on 6A. Detag कर लो. Yes.
Grateful to.
Please, your lordship.